If you've been following crypto regulation in the US, you'll know that the Clarity Act has become one of the biggest pieces of legislation the industry is waiting for. And understandably, a lot of the conversation has become focused on one question: when is it finally going to pass? But I think there's another question we need to start asking: what happens if it does? Because passing the Clarity Act would be a huge moment for crypto in the United States. It could finally answer some of the questions the industry's been fighting over for years, but it wouldn't suddenly mean that America had finished regulating crypto. In many ways, it would be the beginning of the next stage. And when you look at what companies like Circle are already doing, what major asset managers are discussing with the SEC, and what regulators are starting to work through behind the scenes, you can see what the next stage could actually look like. So in this video, I want to explain why the Clarity Act has been so difficult to get through Congress, where things stand now, and then the part I think that's much more interesting: what actually has to happen after the legislation passes. Because this is where crypto regulation starts becoming a financial infrastructure. So let's start with Clarity itself. The Digital Asset Market Clarity Act is essentially an attempt to create a proper market structure framework for digital assets in the United States. One of the biggest problems the industry has faced is that it hasn't always been clear whether a particular digital asset or activity belongs under the SEC, the CFTC, or potentially somewhere else entirely. Clarity is trying to create clearer boundaries between those regulators and establish rules for the businesses operating within those markets. The House passed its version of the bill in 2025, but the Senate has been considerably more difficult. And this is where I think the story sometimes gets oversimplified. You'll often hear this discussed as though Congress simply needs to get everyone into a room, hold a vote, and get it done. But there are still significant disagreements over what the final framework should actually look like. Those disagreements include things like the treatment of securities, consumer protection, illicit finance, financial stability, and conflicts of interest. There have also been major disagreements around stablecoins, particularly whether companies should be able to offer rewards or yield connected to stablecoin balances. That matters because the banking industry is worried about deposits potentially moving out of traditional banks and into stablecoins, while the crypto industry argues that overly restrictive rules could limit competition and innovation. Then there's questions around DeFi, non-custodial software developers, and exactly how anti-money laundering obligations should apply to decentralized systems. So this isn't simply Democrats versus Republicans or crypto versus anti-crypto. There's disagreements between lawmakers, regulators, banks, and the crypto industry itself about where these boundaries should sit, and the clock is becoming increasingly important. Expectations around the bill have deteriorated significantly. Galaxy Research, which earlier this year put the chances of Clarity becoming law in 2026 as high as around 75%, has now reportedly cut its estimate to just 10%. Now, I want to be really clear about what that means. That's not an official probability of passage. It's one research firm's assessment of the political situation. But the reason it's interesting is that Galaxy has been following this legislation closely, and one of the problems it's increasingly highlighted is the calendar itself. There simply isn't much legislative time left in 2026, particularly with the midterm elections approaching. So even if lawmakers can resolve the remaining policy disagreements, they still have to get the legislation through a very compressed Senate timetable. And that's why I wouldn't look at any single upcoming Senate vote and assume that Clarity is suddenly finished. There are still procedural steps, negotiations, and political amendments ahead. But let's say they do get it done. President Trump signs the legislation. What happens next? This is where I think the story becomes considerably more interesting, because Congress can write the law. Congress does not write every operational rule that makes the law work. Once legislation establishes the regulatory framework, agencies like the SEC and CFTC still have to turn that framework into rules that companies can actually operate under. That means definitions have to be interpreted, registration regimes have to be built, disclosure requirements have to be established, custody rules have to work, trading venues need standards, surveillance requirements need to be determined, and regulators have to work out how different parts of the financial system actually connect. That process takes time. So rather than thinking clarity passes, crypto regulation is finished, think clarity passes and the implementation phase begins. Even after legislation passes, regulators could still have months of rulemaking and implementation work ahead of them, with different provisions potentially operating on different timelines. And we can already see companies preparing for that world. Circle is a really useful example. Most companies know Circle as the company behind USDC, but Circle has been building much more than simply a stablecoin. The company's been developing payments infrastructure, institutional settlement products, and blockchain-based financial services designed to connect digital money with the traditional financial system. And that becomes particularly important if the US ends up with a regulatory framework where stablecoins, tokenized securities, crypto trading venues, and traditional financial institutions increasingly interact with each other. Because issuing a regulated digital dollar is only one part of that system. You need to answer questions like, how does that money move between institutions? How does it settle against a tokenized asset? Who holds the assets? How do you verify the customer? What happens when an asset moves from one regulated institution to another? And which record actually proves who owns it? Those might sound like technical details, but they're actually some of the biggest questions institutional tokenization has to solve. And there was a really good example of this at the SEC recently. On the 13th of August, the SEC's Crypto Task Force met representatives from some very significant traditional asset managers, including JP Morgan Asset Management, Franklin Resources, WisdomTree, alongside the Coalition for Tokenized Markets. And one of the biggest issues being discussed was identity. Imagine you buy a tokenized investment fund through one regulated institution. That institution has completed its KYC checks, it knows who you are, it's verified your identity. Technologically, that token might be capable of moving to another institution almost immediately. But the second institution still has its own regulatory obligations. It needs to know who you are as well, so the token can move. Your regulated identity doesn't necessarily move with it. And suddenly the technology that was supposed to make finance more efficient runs into the existing compliance system. That's why the idea of portable KYC or reusable regulated identity is becoming so important. If regulated institutions could rely on verified identity credentials created elsewhere, you could potentially remove huge amounts of duplicated compliance work. But that immediately creates another question. If Bank A verifies you and Bank B relies on that verification, and something turns out to be wrong, who's responsible? That isn't something blockchain technology can solve on its own. Regulators have to establish the legal responsibility, and identity is only one example. Tokenized securities create another problem. Let's say I own a token representing a share in an investment fund. I transfer that token to you. The blockchain now says you own it. But imagine the registered transfer agent's official records still say that I own it. Who legally owns the asset? That question becomes incredibly important if that token is being used as collateral. A bank isn't going to lend millions of dollars against a tokenized security simply because a blockchain says somebody owns it. It needs to know what happens if the borrower defaults. Which ownership record does a court recognize? Can the bank seize the asset? Did legal title actually transfer? This is why there's a difference between technological settlement and legal settlement. A blockchain might be able to finalize a transaction in seconds, but the financial system also needs to know whether ownership legally changed, whether the payment obligation was discharged, and whether the asset can now safely be used somewhere else. And once you start looking at tokenization through that lens, the regulatory challenge becomes much clearer. The difficult part isn't necessarily putting an asset on a blockchain. The difficult part is making sure that everything surrounding that asset moves with it. The identity, the money, the ownership record, the custody, the collateral rights, and ultimately the law. This is why I think focusing exclusively on which blockchain can process the most transactions misses a huge part of what institutional adoption actually requires. Financial institutions don't simply need fast technology. They need technology that works inside a legally enforceable financial system. And this is where the Clarity Act fits into a much bigger picture. Clarity could establish much clearer boundaries between regulators. It could give businesses considerably more certainty about which rules apply to them. And it could remove some of the regulatory ambiguity that's existed in the United States for years. That would be a major achievement. But it doesn't automatically answer every question about tokenized funds, stablecoin settlement, digital identity, custody, collateral, or legal ownership. Those rules still have to be built. And that's why I think the next stage of crypto regulation could actually be more important for institutional adoption than the political battle we're watching today. For years, the industry's been asking, is this token a security? Is this a commodity? Does the SEC regulate this? Does the CFTC? Those questions matter. But once the boundaries become clearer, the questions start changing. How does a regulated institution move an asset to another regulated institution? How does the identity move with it? How does the money settle? Which record proves ownership? Can the asset immediately become collateral? And who is legally responsible when something goes wrong? That is the financial infrastructure layer. And interestingly, companies aren't waiting for Congress to finish before they start building it. Circle is building digital money infrastructure. Major asset managers are exploring tokenized funds. Banks are experimenting with tokenized deposits. Regulators are discussing identity, custody, and market structure. And central banks around the world are experimenting with entirely new settlement systems. So even while the political argument around clarity continues, the infrastructure underneath financial markets is already beginning to change. And that's why I don't think the most important question is simply when will the Clarity Act pass? The more interesting question is, what kind of financial system are they preparing to regulate once it does? Because passing clarity would be a major milestone for US crypto regulation. But for institutional finance, it would be the starting gun rather than the finish line. And I think that distinction is going to become increasingly important over the next few years. If you enjoyed this video and you want more content looking at crypto from the regulatory, macro, and institutional side, rather than just focusing on price, make sure you like the video and subscribe to the channel. And let me know what you think in the comments. Do you think the Clarity Act actually gets through Congress this year? And more importantly, if it does, do you think the US is ready for what comes next? As always, none of this is financial advice. I'm simply looking at the regulation, the infrastructure, and the changes taking place across the financial system. Thank you so much for watching, and I'll see you in the next one.